Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. Looking at a book from Oxford University Press this morning, which is a real treasure for me. I teach, or I have certainly taught in the past, a lot of students on the subject of the law of contract. One area of the law of contract which is fascinating is privity of contract. Difficult subject somehow to put across to some people because they don't quite understand the very basis of every agreement we ever have. Doesn't matter what it is, whether it's actually a binding legal agreement or just some sort of agreement to do something. It's a relationship between one person and another, and of course it's to the exclusion of all else, all other people. Now that's where we start off, the cornerstone of what we do. But this particular book has been written by two real experts, and I'm very pleased to see what has come out of this book, because we hadn't until recently actually got a book which at the right level has been able to talk about this just as a very specific part of the law of contract. Of course you have Chitty on contracts and all the other books that are available, but this one is called Privity of Contract. It's been written by two people who will be known probably to you, Michael Fernston and GJ, that's Gregory Tolhurst. The book itself comes from OUP, Oxford University Press. Now my wife Elizabeth and I talked about this before we wrote the review, and we've given it a title for our review of the following: Lawyers who deal with contracts, which means just about all of you, should acquire this book, because what it does is it actually explains complex concepts, and that's really what I think is the success of this book. We'll talk about the book in a minute. Let me just show you what it looks like first of all. It's a hardback. That's the front. There we go. It's not a big book at all. It's actually running to 300 odd pages, something like that. And you've got a detailed index. Very much the house style of OUP, I hasten to add, all the way through. But some useful index material there. Some appendices there, information, third-party rights. And then you go from that, what is actually a short appendix. You've then got the main body copy. You've got paragraph numbering at the sides there. You've got obviously the usual footnotes there to have the very detailed information which you may well need. All the cases you would probably be wanting to look at, and we're going to talk about a couple of those in a minute, are here. And you've got a preface, and I'm going to talk about what's in the preface in a minute, because we're going to look at Dunlop and Selfridge. Then you've got the 10 chapters listed with the summary of the contents, and then the detailed contents, early history of where we were with privity all the way through to where we are modern stuff today. Then of course you've got legislation, the 1999 Act, then you've got the table of cases, and then from that bit of the old legislation, then a bit of useful abbreviations. Again, that's coming in more and more. I think very helpful to have some of these. UN Citral, for instance, Commission on International Trade Law. I mean, that's just one example. It's quite important to know exactly what the abbreviation is, because that attention to detail can be quite important. Then you see where we are. Got a nice little bit of indexing for each of the chapters, and then you've got the detail of the chapter. It's all logically structured all the way through, paragraph numbering very helpful, so forth. Lovely little book, I must say. I'm very pleased with it. I found it very interesting to look at. This is what we say. Like it or not, human existence does pivot around contracts and or agreements of whatever kind. Collectively, they're the cornerstone of law. And of course, the cornerstone of contractual agreements, one might say, is the concept of the privity of contract. So privity of contract is there. It's the big one, because you know when you enter an agreement with someone that it's between you and him, or you and her. And there aren't any other people involved. But there could be, and that's where the interesting bits start. That's when my learned friends come into it. What a simple and what a complex concept then this is. So complex, in fact, that volumes have been written about it, including this definitive work published recently by OUP. which I'm grateful to review. And the authors, Michael Firmston and Gregory Tolhurst, are acknowledged experts in the subject, which means that lawyers practicing in just about all specialities of law should really have this book to hand as one that excels in authority, insight and usefulness. Quote, "Of all the central doctrines in the common law of contract," say the authors, "privity of contract is the one that is most fractured." Interesting use of words here. Not surprisingly then, certain common law jurisdictions have gone off in different paths in this matter, although reference is made here to reforms that were made in New Zealand in 1982, in England and Singapore following suit in 1999, and that's the Third Parties Act, and an important piece of legislation for anybody. It came in long after I had actually qualified, so that there were quite a lot of changes that became quite relevant at the turn of the century. So as well as lawyers, academics and researchers, we think a wide range of people will be interested in the wealth of case law generated here by the vagaries of this area of law, of which the authors have also provided a quite enthralling historical perspective with references, for example, to Roman law, and so that right at the beginning you see how far back into the mists of the past we're sort of going with all of this subject matter. The authors note in particular that 2015 is the 100th anniversary of Lord Haldane's well-known and historic judgment in the famous case of Dunlop versus Selfridge. Now we know Dunlop and Selfridge, I'm sure, from very basic early years learning of principles of law. It's Dunlop as in tyres and Selfridge as in the London department store. And this pivotal case is acknowledged as having, quote, laid to rest any doubt that the privity rule formed part of the modern common law. In other words, laid to rest any doubts. It does, it is, and it remains so, notwithstanding the statutory tinkering. Also interesting here is the fact that Lord Haldane was a member of the Privy Council in the 1904 Charter Party or Bareboat Charter Party case in Canada of Strathcona Steamship Company Limited and Dominion Coal Limited Company. The remedy here was apparently an injunction to restrain the owners of the ship, that's the Strathcona, from using it inconsistently with the charter. In this mind-bendingly complicated matter, detailed in the book, quote, Solomon would surely have agreed, say the authors. And also, in their words, the book as a whole is aimed at practicing lawyers with a problem in this field, particularly lawyers in England and Singapore, as well as other Commonwealth, that would mean common law countries. And with this extensive footnoting and the other research materials which are available, including the table of cases, the national legislation, international treaties, conventions and other instruments, we think this book will undoubtedly be considered an absolutely essential addition to the well-stocked professional library, especially if you deal specifically with the law of contract on a detailed, contentious basis. And you may find that this is just the sort of thing that may assist you when you've got the warring parties and you're trying to deal with them. The law, the actual publication date is cited at 2015, so the law, I think you can take it as at the beginning probably of 2015. Here's the book again, hardback, side, there's nothing on the back. Just looking, here we go. After Dunlop and the Call for Reform. You see, when I was studying, and I'm sure many of you who are listening to this will remember, that there was a clamour for change, and that's what happened in 1999, when in fact there were some substantial changes. The operation of the law in relation to exemption clauses, for instance, and then you've got the leading cases, which are also covered here. I think very well indeed, with a lot of very useful quotations from the judiciary. I thought, as I say, I think it's a very important book. I did like looking at the other countries, Australia, the US and so forth, to see how they do their business there. But as I say, I mentioned just to finally finish off, this is the bit about where we started with it all, with Roman law, medieval common law, and the rise of a sumsit. I'm not going to go into the Latin, but you probably remember the word assumpsit from all those years ago. I mean, there was a main Latin tag, but the basic, it's the development of the English law of contract was intimately connected with, obviously, the development of debt and covenant, replacing what was that old principle of assumpsit. Anyway, without going any further, read the book. It's great fun. You've got all the cases there, Tweddle and Atkinson, a lot. And if you like, as I do, contract law, you'll find this fascinating. And what I would advise you to do, if you really are desperate to look at it even more, is have a look at it and compare it with Chitty on Contracts. Because I'll be asking questions later. No, I won't. I just threw that in. Thank you to all concerned, though. It's really been an excellent book for me to read. And as you gather, I really loved it. It was great fun. Thank you anyway. Bye-bye.